English legal shorthand 100 words per minute. Ready, start. The Supreme Court has thus emphatically held that both consent of the opposite party and leave of the court are required before any legal practitioner is permitted to represent either party in such proceedings. Stop. This view has been reaffirmed by the decision of the Supreme Court in the case of Krupp Industries India Private Limited and others (Supra). Thus, it is necessary to examine the factual matrix in this case, keeping in mind the twin test of consent of the other party and the leave of the court. Stop. Admittedly, applicant before me is a small laundry establishment employing 4 to 5 workers. Stop. The record shows that applicant appeared through his advocate at the initial stage before the Labour Commissioner, which was then dismissed for default. Stop. It is seen that respondent number 1 employee thereafter filed reference IDA number 158D of 2021 and invoked section 36 to restrain such representation. Stop. The Labour Court by its order dated 1/12/2023 rejected applicant's request to emerge advocate to conduct cross-examination of the worker and trial. Stop. The correctness of that order is under challenge. In this case, it is pertinent to note that during initial proceedings before the Labour Commissioner, applicant was duly represented by advocate and reply to the original application was filed by the advocate. Stop. However, due to respondent employee's absence in those proceedings, the case was dismissed for default. Stop. However, a respondent employee thereafter filed his preliminary objections for the first time in a subsequent proceeding, that is reference IDA number 158D of 2021 before the Labour Court. The Labour Court, while rejecting applicant's plea, failed to exercise its jurisdiction in the letter and spirit of section 36(4). Stop. It is seen that court's refusal was mechanical and solely based on the objection raised by respondent employee. Stop. The order does not disclose any reason or consideration as to whether denial of representation would cause prejudice to the respondent employee or affect the fairness of the proceedings. Hence, the approach adopted by the learned Labour Court defeats the purpose of the provision and offends the principles of natural justice in the facts of the present case. On these lines, it is necessary to set out the decision of this court in the case of T.K. Varghese versus Nichimen Corporation, wherein court held that consent cannot be withheld without any reason or justification. Stop. Relevant paragraph numbers 9, 10 and 11 of the said decision are reproduced below for immediate reference. Moreover, if we consider the history of industrial litigation, the legal fraternity has its major contribution to the development of this branch of law. Stop. It would be totally unjust to deny the legal community access to this field, and the courts and the tribunals would face great handicap if they do not get proper assistance from the legally trained persons in their decisions, which finally land in the higher courts. Stop. The judgments of the lower court do reflect the kind of assistance received by them. Stop. If facilitate the higher courts, if the decisions are written after good assistance from the bar. Stop. The foundation of the justice is the fair and equal fight between the parties. Stop.